This is an AZ Court Help Legal Talk on changing a division of property from a divorce by Robert Current of Ayala Law. Thank you.
Yes, today I guess the question was raised that can you change the property division after the divorce decree is entered, after things are final? And generally speaking, the state law itself, the state statute says no. There's a couple exceptions to it, and primarily there's a large exception to it because of child custody and legal decision making. Legal decision making and parenting time are issues that are usually in the decree that don't involve property, and those get modified. So it's not unusual to see divorce decrees be modified over and over. But as far as the property goes, there's actually a statute. It's in Title 25, which has to do with family law in general. In Chapter 3, dissolution of marriages, at 25-327, I've pulled out the full text to it to look at, but basically it says that the decisions involving property may not be revoked or modified. So the first step, I guess, would be to acknowledge that the courts generally want to follow the law. There's some rules about exceptions for that, but if you can move forward with your issue without having it revoked or modified necessarily, the first step is to see if there's just something that can be clarified. Often there will be something in the decree that's not exactly clear. So something and there's a rule in the Arizona rules of family law procedure, Rule 84 here, that spells out what the grounds for asking for a clarification are. Is if something's confusing and susceptible to more than one interpretation. So this comes up a lot when you're reading a decree and there's like more than one item and it just says that one, that just addresses the one. So like if the question is which one, so you have two cars and the decree says must transfer the title of the car. Well, that's a property decision, but which car is it? So, I mean, that can happen. That I've seen that happen in issues where like there's two houses and one gets sold early on and the money's divided. And then the second house, one person was going to stay in and the other person and buy the other person out. And the decree will say that the house will be sold and the money divided, and they're referring to the other house. So sometimes it's just an issue of which thing that they're talking about. Sometimes it's as simple as the judge just leaving out a word or being overly vague. So those are the first ones to address, and those are pretty straightforward. You can file a motion for clarification under Rule 84. That I know the librarians there, I'm sure, can help you find the rule, and it's a fairly straightforward question to the judge. Another example I've listed here is, so you've argued over the antique china, and then you know who's going to get it. It's been resolved since the very beginning. It hasn't came up in the case for a year, and then you get the decree, and all the contents of the kitchen are awarded to one person, and the china isn't mentioned, and that was the one exception. That point is just a motion for clarification because it was just overlooked or forgotten. It wasn't necessarily a property change in the intent. It was just something that wasn't completely clear in the decree. So those are straightforward, but sometimes it's a little more complicated than that. Now, to get a look at what the statute actually says, here's the full text of the statute. And the only sentence in here that really applies to this question is this one right in the middle. And I've zoomed in on this so you can see it a little better. That property divisions may not be revoked or modified. And it sounds pretty final, but then there's an exception. It's unless the court finds the existence of conditions that justify it. So what would the conditions be? How do you get it reopened? So we can go through that. Now, they've pointed out in the very beginning that there's exceptions specified in another statute. So 25.327 refers you to 25.317 in sections F and G. So if we look at those, they kind of show what I was trying to explain a little earlier, that the modifications generally have to do with children. They don't have to do with property. And if you look through the exceptions that they spell out, they kind of just reinforce that getting a property modification is difficult and that they're not going to be modified. So there's not really a lot of hope when you look in the law itself for the exceptions. So you have to look to the rules. Now, I guess the majority of you out there aren't attorneys. So there's three pools of legal knowledge that you have to draw from in a case, in almost any case, and it's the state statutes, and then the court's rules, and then the court's prior decisions. And the three of them kind of work together. So the rules tell you how to get things done in court. The statutes say what the limits are in the laws, and the cases kind of flush out some of the details that you can't find in the statutes. So to bring your challenge, you have to follow the rules of the court to get things reopened, and you have to follow the laws to have the content of the motion in your pleading to get things changed. So if we look through the rules, there's 4 rules that apply to this particular situation. The big one that's probably going to be used, we'll talk about last, is Rule 83, which is actually directly attacking trying to get the judgment amended or altered. The first and easiest, most straightforward one we've already covered, which is Rule 84. It's just a motion for clarification. Something technically in the writing didn't make sense and was unclear to someone. So that one can be filed. It's fairly straightforward. Then the 2 other things that we haven't mentioned yet are a motion for reconsideration and then just appealing the case in general. The motion for reconsideration is something that involves more than just a clarification. It's an actual legal decision that you're asking the judge to take a look at, or a fact pattern that you believe he hasn't fully analyzed. It's not saying, it's saying that I don't think you understood it, rather than I think you understood it, but you said it wrong, would be a motion for clarification. A motion for reconsideration would be, I think you missed something. And it's a little dangerous to tell a judge that he doesn't know what he's doing and he's done something wrong. So you want to word it carefully. But if it's clear that there was something that wasn't considered and he needs to consider it again, it would be the Rule 35.1 motion for reconsideration. And then all of these are these family law rules, all the top 3. The 4th one is an actual appellate procedure, which steps outside the family law procedure, and it's kind of the last step that you would take. It's pulling it out of the family court into the appellate court, saying that the family court got it wrong. You want a different judge. You want all the laws looked at again. Now, there's a difference between how these operate. In some of these rules, only the facts can be challenged, and in some of these rules, only the law can be challenged. So if you're asking for clarification or reconsideration, you can challenge the facts that, someone, let's say, did not present something correctly. In the appellate procedure, you're only allowed to challenge the law. So you can't say that I think, what he has is worth more than what I have, because those numbers have already been worked out and decided. But if you think that the judge has applied a law that says one thing and he applied it another way, you can definitely file for an appeal. And so the motion for reconsideration, generally speaking, this is the rule for it. The text of Rule 35.1, it's a special rule. Generally, you're asking the court to just look at it again and be sure that it's right. And often these are denied. So the procedure is a little different than most of the other motions that you'd file in court. When you file a motion for reconsideration, because the judge can deny it, and because it's after the case is already resolved, they kind of shorten and abbreviate the procedure. So normally when you file a motion, the other side has time to reply to it, and then you can respond to the reply, and then you get an argument in front of the court. When you file a motion for reconsideration, you can't request an oral argument, and the other side does not automatically get to reply. The judge first has to approve the reply, and then he'll send out a notice that the other party can reply. That means he's considering it, but he could deny it before he even does that. So it's generally a little different procedurally, but basically it's just a Rule 31 or Rule 35.1 motion for reconsideration. Outline what you think the details are that need to be looked at specifically, and offer it up to the judge. Now, when you do this, if there's a very good chance that you won't win it, and if you think that it's a legal issue, that the clock for your appeal doesn't stop running just because you filed a motion for reconsideration. So it is possible that even if you filed the motion for reconsideration, you still need to be getting an appeal ready to file, a notice of appeal, which we'll get to in just a second. But this would be your first step after, if it's not just a motion for clarification, you want to consider a motion for reconsideration. And this would be one of the ways to go about it procedurally in the rules. So when you do this, you have to make sure that you look at the state laws that say what the judges are allowed to do and not allowed to do. So they have to have a condition that justifies reopening the judgment. So they can reconsider it, but there has to be some condition, and that's typically defined, fraud, mistake, some legal issue. If we look at the details for the appellate procedure, they're pretty clear and kind of long. And since I don't really want to get into a lot of legal details on it, I don't think you need to read everything in here. At this point, if you're filing an appeal, you probably should already be talking to an attorney about it. The thing to catch in here is the appeal's filed under Rule 8, but Rule 9 is the one that defines how or when you can file the appeal under Rule 8. So once you have a judgment, if you don't agree with the property division and you've looked at motion for clarification, that isn't going to do it. You probably are going to file a motion to reconsider. And even if you filed that motion to reconsider, you have to think about the fact that if you don't win that and you need to appeal it, you only have 30 days from when you got the decision on the property division to file your notice of appeal. So your clock's running, whether you file one of the motions for reconsideration, whether you file a motion for clarification, the clock's still running. You might still need to file your notice of appeal after 30 days. How could the law be applied incorrectly? And how would that qualify as to reopen a case? There's a few technical details in the laws that sometimes get mistaken, and these get into very specific details of how you think the property was awarded wrong. But sometimes it's because they value something wrong. I've seen rarely, a long time ago, but I mean, there's an example like a home appraisal needs to be based on the sales. And I brought this one up because the market's changing again. This happened last real estate bubble. This might start happening again. If an appraisal is based on listings in the neighborhood or not actual sold properties, the value might be high if the market's crashing, and it might not qualify as the standard that the experts use for the appraisal. So the legal application of facts and the legal standard used to determine the expert become into question. Say that the property wasn't owned by you or it's in another state. Sometimes one person will have a vacation home that they say that's theirs, but it's really owned by the family and it's in Mexico. And there's no way for anyone to verify it in the court while the trial is going on, and the judge awards that property to someone. Well, if it's not in Arizona And if it turns out that the person who the court thought owned it doesn't really own it, it was owned by an uncle, or it was just a family vacation home or something, the court lacks jurisdiction to act on that property to start with. It's not part of the case. It's not owned by one of the parties in the case. It's not even in the country. That's an incorrect application of law. So then you can definitely appeal. If the property was awarded, like occasionally the judge will, a court will award, lots of people in Arizona have guns and they'll award guns to one person or the other. Then the husband, wife, there was domestic violence. So there's a restraining order of protection, and they ask that the gun be transferred legally through a dealer, and the dealer denies it because the background check denies it because there's an order of protection. But there's a conflict there because the federal law won't allow the firearm to be transferred, but the court order allowed, or the court had the decree state that it was awarded to the person who can't have it. So there becomes a conflict. Sometimes pensions are considered property, and the federal laws preempt how the courts in Arizona can allocate that property. And what is equitable? I mean, now that one's pretty wide open and very tough to challenge, but property division needs to be equitable in Arizona. And if it is grossly inequitable for some reason, then it's definitely appealable. You have to jump. So it's rules of civil procedure that define how to get relief from judgment. So basically, most of these are, you're telling the judge you made a mistake. And if you're doing that, you need to be really sure and you need to be really clear. You can't be really dramatic about it and saying it seems unfair and things aren't what I wanted. You have to point out that there was something actually wrong. And this is the outline of the rules that the court will look for and acknowledge. So if there was an actual mistake, clerical mistake, if somebody wrote the number down, if you were supposed to get $987 and they wrote $789 down, it was someone transposed the numbers. It was just a mistake. But those are things that you can get relief from the judgment because it's a mistake. It's in the judgment. The court's obliged to fix it. You have found out that there's fraud or there's evidence that someone has intentionally deceived you. Say I get the contents of the barn and didn't know that there were three antique Ferraris in the barn, and he was intentionally hiding it, and you were never allowed to go look at it. Never had any reason to suspect it. He's always acted broke his whole life, and then you find out, you probably have a pretty good shot at that point because it was an intentional act of misrepresentation. But this is really where you want to look for one of the conditions that needs to be met in one of the motions that you're going to file, if you're going to go anything beyond just asking for a clarification. You're asking for a modification somehow, you need to make sure that you qualify. Now, it does end in saying any other reason justifying relief. It's kind of a catch-all, and there are a lot of times this is turned down. It's just in case, like the federal law, when the federal law changed the military retirement and defined it as property and gave guidelines on how it was divided, it wasn't in the state laws. That one was caught in the catch-all, any other justifying, but that one's pretty tight. It's there, but I wouldn't rely on that. I wouldn't, unless you have a really strong case. Don't just think it's not fair as justifying relief. Find it somewhere else. This is the kind of final slide. This is the answer of how you actually get, if everything else fails, if it wasn't a clarification, this would be before you would appeal. I mean, you want to be considering this before you appeal. But if you can't get through it with Rule 82, if you can't get through it with the motion for clarification, then you want to go straight ahead and try to file to alter or amend a judgment. And I would warn you that this is quite often unsuccessful unless done correctly, because the judge needs to find the proper grounds, and then has very specific rules about how he can go about, how long you have to respond, how long you can file them, how long it takes to file the motion, take a look at Rule 83. 83 is going to be the one that's going to define the outlines of what is possible and what's not possible. And if you can't find it in there, you might not like the answer, that sometimes they're final for a reason, because the court doesn't want to go back and revisit property division. It's really frowned upon. No one likes it, because once property is given to one person, it's considered theirs, and they don't have to be accountable to anyone else for it after that point. If I'm awarded a car and I need money, I'm going to go sell the car and I'm going to use the money to pay my bills. And then you want to bring me back to court and tell me the car's yours. The judge doesn't, he's already decided. So you have to make sure that it's more than just an emotional, I'm attached mistake the judge made. He doesn't understand how important it is to me. It's got to be an actual reason, a mistake, a misunderstanding, fraud, something you can actually find in the laws and present to the court. So just reviewing again the grounds, you need to make sure that one of these applies, that there was some mistake, there was some irregularity, there's some misconduct. Accident, I mean, you could be surprised, you find out that, you know, something was worth a lot more than you ever really thought it was, and no one had even considered it. New evidence, it's basically got to be on this list. And if it's on that list, you have a chance. If it's not on that list, you're gonna have a hard time struggling for a way to get into court and have the judge not just deny your motion right out of the gate. So that's where I'll end it. I guess I will leave that slide up because it probably covers the most important things you need to know to get the judge to take your action to reallocate property seriously. So, but thank you for having me.